Federal versus State Court Systems and Jurisdiction, ADR and Small Claims. ADR stands for Alternative Dispute Resolution. It's another way to get your disputes settled in court without actually going to trial and using the formal court process. There are two types of ADR that I want to focus on today: mediation and arbitration. Mediation is a structured process in which a neutral third party meets with both of the parties having the agreement and tries to help them find some sort of mutually agreeable solution. Courts are really pushing mediation lately because it's really a way for the parties to get a win-win. There's no winner or loser, but the parties can come together and come up with a solution which is going to make everyone happy. The mediator is the person who's that neutral third party, who's going to mediate between the two parties with the disagreement. The mediator is chosen by the parties. The mediator can either be someone who's private, who's hired from outside, or sometimes in the court, when you're going to go to trial, the judge will offer up a court mediator for parties who want to step outside and see if they can resolve their issues with the mediator first before going to trial. The nice thing about mediation is that the mediator actually has no authority to impose a solution on anyone. So if you don't like what's going on, or you decide that you can't come to a solution, you can always go back and have your day in court. The mediator can make a recommendation, but if the parties don't wish to go with that recommendation, then they don't have to. The mediator is there to guide the parties to a resolution. Lawyers can be present and can help out, though they don't really have to be, and they don't have any special authority in the mediation room. They're just there to help the mediator and to help the party that they're representing to come to a mutually agreeable option. Mediation is required in some courts, particularly for issues like custody disputes. There is both private and public mediation. Private mediation are private organizations and companies who sell their services. One in the Bay Area is JAMS. They are a group of retired judges and mediators who come together, and you can hire them like a retired judge to be the mediator for your case. There's also public mediation, which is appointed by the court or provided by the court, or ones that are subsidized by the court or government in some way. Low-cost mediation includes the organization SEEDS. Arbitration is a different animal. Arbitration is kind of like a mini trial. It's a proceeding in which both parties agree that instead of going to court, they're going to go to this outside third party who's going to conduct a semi-trial for them and decide which party is right and which party is wrong. Unlike mediation, when you go to arbitration, you are bound by the decision of the arbitrator. So if you don't like what happened, you don't have the option of going to court. Instead, you're stuck with the arbitrator's decision as if it was a judge's decision. Now, the parties do get to choose the arbitrator who's going to make the decision about the dispute. However, oftentimes the arbitrators are already ones that have been used for a long time by the parties who are involved. For example, you will see clauses called arbitration clauses. In arbitration clauses, they're in contracts, and they say things like, if we ever have a dispute and you want to sue me, instead of suing me, we have to go to arbitration, and the arbitration will be binding. Believe it or not, this is probably what a lot of your credit card statements said when you first signed up for the credit card and all of that fine print which you did not read. A lot of organizations and companies, especially large companies, avoid the costs of litigation in court by submitting the parties to arbitration. You can contract into anything, and so if you agree by signing your name on a document or signing up for the service that you will go to arbitration, then that party who had that contract in the first place is going to argue that you can't sue them. You have to submit to arbitration instead, whether you like it or not. Arbitration is similar to a court in that you can bring witnesses, you can bring evidence, and you can even bring lawyers. However, it is not given the same system of formal review that a court would give to you. It's almost always final, and there is no way to appeal. It also costs more than a normal court costs. Court costs when you're filing and answering fees can definitely run up, but expect to pay between $750 and $2,000 for an arbitration process. Let's talk a little bit about small claims court. We're going to get into the part of the course now where we start talking about different types of civil cases. In case you haven't figured it out already, all the things we're going to be talking about in this class relate to the civil court system. And so we're not going to be talking much more than we have already about the criminal courts. We're not going to be talking about civil law. And the first part of civil law that we want to discuss is called small claims. The amount in controversy in the small claims court in California must be $10,000 or less. So if you have an accident and you want to sue the person you got in an accident with for $15,000, it cannot be done in small claims court. It has to be below that $10,000 or lower amount. There is a limit of $2,500 after the first 2 lawsuits in a year, and businesses have a $5,000 limit with a $2,500 limit after the first 2. The public policy reasons behind this is that the courts generally don't want people going around suing everybody for no reason or being extremely litigious and suing people for $10,000 at a time over and over and over again, but believe that individuals should have the ability to bring small claims before the court without having to hire lawyers or go through an expensive process, and they assume that this doesn't happen very often, definitely not more than once, maybe twice in a given year. In the small claims court, lawyers are not allowed. So even if you have a lawyer on retainer, they will not be able to argue for you within the small claims court system. The judge is just going to allow the plaintiff and the defendant to argue for themselves. They can bring witnesses and they can bring evidence, but they can't have a lawyer who's going to argue on their behalf. Who can sue in small claims court? You must be mentally competent and over the age of 18, or you can be a business, and you can go as the agent or representative for your business if you feel your business has been wronged. The only exception to this is that third-party collection agencies cannot sue in small claims court, as they are barred by statute. Statutes of limitation. Statutes of limitations are deadlines for filing lawsuits. There are all sorts of different deadlines strewn throughout the statutes and codes which say how long you get from the point of injury, from the point something happened to you, to when you can file a lawsuit about it. For example, if you slip and fall at a grocery store and break your leg, you have the right to sue in a personal injury lawsuit. However, you only can sue from that particular injury, that particular incident, for 2 years after the injury or 2 years from the date that you discovered that you were injured. This is so plaintiffs don't so-called sit on their rights. The idea is that you can't hold a defendant and bait them out forever. If you have a claim, pursue it and get it done with. Different types of cases have different types of statutes of limitation. When there's a breach of a written contract, there's a 4-year statute of limitation versus a 2-year. When there's an oral contract, it's 2 years from the date of contract. If it's a damage to a personal property, it's 3 years. And if you're collecting debt with a court judgment, it goes all the way out to 10 years. There are some situations where you can actually pause the statute of limitation, make it so that the time does not run. And this is called tolling the statute. And this is when the statute of limitation is suspended. This happens when either the defendant is out of state or the defendant goes into prison. Sometimes it can happen if the defendant is judged to be insane by the court or is a minor. Sometimes they'll have a 2-year statute of limitation, but they won't actually be able to bring the lawsuit because they're under the age of 18, and so the statute of limitation would toll until they gain the age of majority and have the full ability to bring their own lawsuit. Sometimes the statute of limitation will toll when the plaintiff dies, and it takes some time for the defendant to find out who the next plaintiff would be in the case that the defendant is having to deal with. Or it takes time for the plaintiff's estate to figure out whether or not they want to pursue the case with a different plaintiff or with this estate acting in the plaintiff's stead. So let's talk about jurisdiction and venue. Where can a small claims suit be filed? Well, a suit can be filed in a couple of different places. It can be filed where the defendant lives. It can be filed where the business is located, if it was a business that you have an incident with. It can be filed where an injury occurred or where the contract was signed. It can also be filed where the buyer lived, if there's a consumer transaction, or where goods or the vehicle in question are kept. Now, these aren't only jurisdictional issues for small claims court. We call this jurisdiction in general, and this is for all civil cases. The first thing you want to find out is where you can bring that lawsuit. We talked a little bit about bringing it in federal court versus state court, but how do you know which county you should go to, or which state for that matter? These are the questions where you should ask. This is the question that you should ask, right? You can take a look at where the answers to these questions are, and then you can choose the particular forum. So what do you need to do if you decide you want to sue someone in small claims court? The first thing that you have to do is you have to contact the other party. It's best to do this in writing, and you need to request payment. You can't sue somebody if they didn't have any idea that you had to beef with them in the first place. So the court says the first thing you have to do is you have to get a hold of the other party, and you have to request payment. It's only if they refuse to pay you the money that you can then complete and file the form Plaintiff's Claim and Order to Defendant. This is the small claims form that gets you started. And you would file this with the court, and you would pay the filing fees. Depending on the county or the state that you're in, your filing fees can vary, so make sure to check with your local rules so that you know what the filing fees are. Some courts also offer fee waivers for certain cases, and you may be able to waive the filing fee by filling out a fee waiver form. After these forms are filed, then it is the plaintiff's responsibility to serve the defendant. Let's talk a little bit about service. Service of process means getting the papers that were filed by the plaintiff into the defendant's hands. Each and every defendant must receive a copy of the plaintiff's papers. So if you are filing a lawsuit against Huey, Dewey, and Louie, then Huey, Dewey, and Louie each have to get a copy of the plaintiff's lawsuit separately. You cannot just put all three names on one lawsuit and give the copy to one of them. Each of them must receive a copy of the papers. When you're dealing with small claims court, you have to receive these at least 15 days before the hearing, and if Huey or Dewey happens to live in a county other than where another defendant lives, if the plaintiff and defendant happen to live in separate counties, or they do business in separate counties, then it's going to be 20 days before the hearing that they need to be served. What are the different ways to serve? Well, there are 3 separate ways. The first is by certified mail. The court clerk will actually mail it out for you if you pay a fee of $10 is the jurisdiction where I am. Again, check your local court rules. And the service is complete when the defendant signs for the certified mail when it arrives at his door. The second way is through personal service. All you have to do is find somebody who's over the age of 18 who is not the plaintiff to bring that copy of the documents to the defendant and personally hand it to them. So it can be your friend or your neighbor. It can also be someone called a process server. A process server is someone whom you hire to do personal service for you. Sometimes the sheriff's office provides this service for a fee. And thirdly, there's substituted service. This is when you serve the documents not on the defendant themselves, but on a competent member of defendant's household who's 18 years old or older. Say your process server goes to the defendant's house and finds out the defendant is at home, but defendant's wife is there. Defendant can give the copies to the process server can give the copies to defendant's wife as long as she is over the age of 18. Similarly, the process server can go to defendant's place of business and give the documents to someone who's in charge of the business. Again, they have to be competent and over the age of 18. And if substituted service is the way that the person is serving, then there also must be a copy which is mailed to the defendant. Now, bear in mind that there are different laws for serving defendants when there are different types of cases. In an unlawful detainer, for example, you may not serve simply by certified mail. It has to be personal service or substitute service, and if you want to serve by mail, you need to get special relief from the court by filing a motion. So be sure to check your local rules before serving any other documents aside from small claims. On your court date, what do you do? Well, if you're a plaintiff, you come and you be polite. You tell the judge exactly what happened. Use those 5 different questions that you were taught when you were doing journalism back in grade school. The who, what, where, when, why, and how, or however many that is. You'll bring in your witnesses and you'll present your evidence. It's very important that you only talk to the judge. This is not for you to argue with the defendant who's standing across the table from you. You are presenting all of your questions, all of your information to the judge. The defendant will get their chance to talk. And so it's important that you just present your case calmly and coolly to the judge so the judge understands what your side is. Also, be prepared to answer questions. The judge wants to make sure that the judge completely understands your side, so questions might be fired in your direction. This tends to trip up a lot of people, but don't worry about it. The judge just wants to understand. The judge is not grilling you or cross-examining you, but trying to understand your case from your point of view. If you're the defendant, make sure to show up. If you can't show up on the particular day of your hearing, you can request a continuance and to postpone that hearing date, but you've got to do it at least 10 days before the hearing. So it's a bad idea to not show up to your court date or to show up the day afterwards and say, oh, I couldn't be here because. If you don't show up, a default judgment can be entered against you. A default judgment means that the plaintiff can win automatically, and that's simply because the defendant didn't show up. You have 30 days to file a request to have the judgment set aside in small claims. So if you have a really good reason for showing up, like for example you were in the hospital, then you can tell the judge in papers, it would be called a motion to set aside the judgment, Your Honor, the reason that I wasn't able to show up to hearing was that because I was in the hospital. Here's my medical documentation, and if you're able to set this judgment aside, I believe I can provide a defense that would be more favorable to me in this case. What happens when you don't like what happened with the small claims appeals answer? The judge came down and made a decision. What you can do depends on which party you are. If you are the plaintiff, meaning you were the one who sued in the first place, you actually have no right to an appeal. The only time that you're going to be able to appeal the judgment is when you're correcting a clerical error or a legal mistake. And you have 30 days to bring this particular appeal. So it's got to be a situation where you're really looking at one of these 2 issues, not simply because you don't like the answer that the judge had for you. If you're a defendant, you can also appeal within 30 days, but in this case, you can appeal for any reason you want, and this is going to result in a new trial in Superior Court. The case will start over from scratch and will be considered what's called de novo, which is starting all over again, of new, or new again.